First things first, I apologize for the genuinely bad lighting. I'm in a hotel room where I'm getting the worst possible lighting, I might say. Genuinely bad lighting. No natural light. I guess there's some back there, but it doesn't really come through. So apologize for the bad lighting. All right, let's talk about the Supreme Court's decision on Wednesday, April 29th in Calais v. Louisiana. Let's talk about this decision because this is a landmark decision of the Supreme Court. It's a major decision and it's, for lack of a better word, terrible. It is a genuinely horrible decision that primarily serves to destroy what's left of the Voting Rights Act. Before we get into the decision itself, or at least the main takeaways, the things I think you should know, let's go real quickly through the Supreme Court's recent Voting Rights Act jurisprudence. So the first big case is Shelby County v. Holder in 2013, when the court, a majority of the court, 5-4, with an opinion written by John Roberts, holds that Section 5 of the Voting Rights Act, which instituted something called preclearance, meaning that covered jurisdictions had to send any changes to voting plans to the feds, to the Justice Department, to get them pre-cleared to go into effect, because these covered jurisdictions had histories of voting discrimination. The Supreme Court ruled that preclearance in Section 5 was unconstitutional for what essentially was a made-up reason, that the Constitution says you have to treat all states equally. The Constitution does not say this, but John Roberts said it did, and thus Section 5 was struck down. It is possible, legislatively, to do a different form of preclearance than the one that was on the books. The one that was on the books and reaffirmed by a nearly unanimous Congress in 2006. But Republicans have turned so against federal voting rights protection that unless you have a Democratic trifecta and no filibuster, it's not really possible. Part of the reason why I don't think it should be a filibuster. About 10 years later, in a case called Brnovich v. DNC out of Arizona, the court looked at Section 2 of the Voting Rights Act, which was kind of if Section 5 is a prophylactic against voting discrimination, Section 2 is a part of the law that set out the ways that people could sue for their rights and get judicial remedies. And in that case, in an opinion written by Samuel Alito, another longtime opponent of the Voting Rights Act and a longtime opponent of expansive federal protection of minority voting rights, the court limited Section 2 to basically make it impossible for a private actor to sue, stating that there's been voting discrimination. And since that case, there has not been a successful Section 2 case aimed at voting restriction. So congratulations, Samuel Alito. There's another case that isn't related to the Voting Rights Act, but is related to voting rights. That is Rucho v. Common Cause, which the Supreme Court held that it can't do anything about partisan gerrymandering, that it might be unconstitutional, but it's not for the courts to decide. It is convenient, I will note, that all of these cases tend to help the Republican Party. Conservatives will say that, oh no, the court's just following the law, but I will note the convenience of this. But the court says we can't do anything about partisan gerrymandering. It's not judiciable. Now we're here to Calais v. Louisiana. This case has to do with the creation of a majority-minority district under Section 2. So in a 1982 revision of Section 2, Congress allowed for the creation of majority-minority districts under the recognition that it was still possible to craft voting rules that would effectively deny minority groups effective representation in Congress, deny them the ability to vote for the representatives of their choosing. So Congress remedied this, amending Section 2 to allow for this. In this case, in order to comply with Section 2's requirements, Louisiana was forced to create a second majority-minority district. The state then sued, saying that this was a violation of the Equal Protection Clause of the 14th Amendment, that this was an unconstitutional use of race in redistricting. And the Supreme Court agreed that this was an unconstitutional use of race. Sam Alito, who wrote the opinion, said that vast social change in the South made such considerations unnecessary. He insisted that discrimination that happened years or decades ago, as well as present-day disparities, were entitled to much less weight when thinking about discrimination in voting and the use of race in drawing districts. And he said that if states draw districts in such a way as to dilute the voting power of minority groups, as to deny them the ability to elect a representative of their choosing, that this is not necessarily illegal racial gerrymandering. Instead, if there is a neutral explanation, say partisan gerrymandering, let's say, for example, that most of the black voters vote for Democrats, And then you district or gerrymander in such a way as to prevent those Democratic voters, who all happen to be black, from electing a Democratic representative. The court says that's acceptable. You can do that. And if you want to prove racial discrimination, you have to have explicit evidence of it. You basically have to have someone turning to camera and saying, I'm doing this to discriminate against black people. In the absence of explicit evidence of racial discrimination, then any kind of gerrymandering goes, even if the effect of it is to gerrymander on racial lines and prevent the ability of minority communities to elect someone of their choosing. Now, I will note that one thing this will allow Republican states to do, states where many of these majority-minority districts were located, what it will allow them to do is wipe them out entirely. In net, Republicans, should they choose, a bunch of new seats in the House, as well as down ballot in state legislatures as well, because the biggest effect of the Voting Rights Act was actually on helping black voters and other minority voters attain meaningful representation in state houses. I think this ruling is pure sophistry. It is pure sophistry. It is actually insulting. It is insulting to look at us with a straight face and say that even though race tracks partisanship in the South, even though the reality of racial polarization in voting means that in much of the South and other places as well, that there is a direct relationship between race and partisanship, that everyone knows this and that no one is stupid enough to say on camera or in paper that they're discriminating on the basis of race. I think to look at all of this and then conclude that actually we shouldn't worry too much about racial discrimination in voting, racial discrimination in redistricting, things have changed, I think that's just, like I said, insulting. And moreover, allowing for racial gerrymandering as long as there's some fake leaf of neutrality is basically the way Jim Crow worked. And I think you should look at this ruling as more or less recapitulating the way Jim Crow worked, which actually wasn't necessarily through explicit prohibitions on black voting, but through the same kind of facially neutral, on its face, non-racial rules and restrictions that ostensibly applied to everyone, but really only weighed heavily on one particular group. States could, if they want, under Alito's ruling, under the Supreme Court's ruling, find some way to gerrymander white voters out of representation of their Republicans. But we know, I know, you know what this is going to be used for. He knows what this is going to be used for. To add insult to injury, the court is using the Equal Protection Clause of the 14th Amendment to argue that actions taken to remedy past discrimination, and yes, in places like Louisiana and Alabama and Mississippi, where racial polarization runs so deep that these are voters who could not elect a person of their choice in the absence of majority-minority districts. Using the Equal Protection Clause of the 14th Amendment to forbid states, forbid Congress from allowing the creation of districts so that people can get representation is perverse. It's perverse. Now, the underlying theory of this vision of the 14th Amendment and the 15th Amendment is that these amendments, the Reconstruction Amendments, prevent classification according to race. They're colorblind. There can be no classification according to race. And thus, if there's no classification, well, we can't classify white people as white, we can't classify black people as black. Everyone will be treated equally by the political system when there's no classification. If that sounds stupid to you, it's because it is. If that sounds familiar to you, it's because it's an echo of the court's decision in Plessy v. Ferguson, where it held that separate could be equal because both whites and blacks were being kept separate. No one was being classified. In addition to being, I would say, logically silly, it also cuts against the clear meaning and intent of those amendments. Think back. Those amendments are a response to the Civil War. They're an attempt to deal with the afterlife of slavery in the immediate wake of emancipation. Now ask yourself, what was the problem with slavery? Was the problem with slavery classification? Was the problem with slavery the fact that some people were treated differently because they were black? Or some people were treated differently because they were white? No. That is not the problem with slavery. The problem with slavery is not classification. The problem with slavery is subordination. The problem with slavery is that some people, on the basis of race, were subordinated. That is the key verb. They were subordinated. They were exploited. They were subject to violence and exclusion. And the Reconstruction Amendments, the 13th, the 14th, and the 15th, were written explicitly to deal with this question of subordination, to deal with the realities of subordination. And they recognize, and the people who wrote them recognize, that dealing with subordination might require some measure of classification for the simple reason that only one group of people were subordinated in this way. And so to ignore that, to treat that as if it's constitutionally irrelevant, would be silly. It would be silly. We create the Freedmen's Bureau not for all people who might have just happened to be harmed by the Civil War, but by the particular class of people who were harmed by slavery, right? The goal was to uproot subordination. It wasn't to deal with classification. But a constitution that includes a prohibition against subordination, that empowers Congress in each of these amendments, says that Congress can bring them into effect through all appropriate legislation, which is another way of saying that Congress can do what is necessary and proper to effect the goals of those amendments. An anti-subordination principle in the Constitution that also empowers Congress to do something about it is immensely powerful. These are amendments that would allow Congress broad authority to uproot the badges and incidents of slavery, which you can read as racial discrimination, which you could read as systematic inequality, which you could read as any number of things. These amendments would do what is necessary and proper to protect the equal citizenship of all Americans, to ensure that all Americans can enjoy the privileges and immunities of American citizenship, a phrase left undefined, but potentially quite expansive. These amendments allow Congress to do what is necessary and proper to ensure equal protection, substantive equal protection, not just formal equal protection, but truly equal protection, which means that some people might need to be protected in different ways than other people. These amendments allow Congress to do what is necessary and proper to prevent discrimination in voting on the basis of race. And that can mean many different things. That can be quite broad. And so if you take the amendment seriously, what you find is that they empower Congress to do a whole lot. They empower Congress to uproot systems of hierarchy and domination, should it choose to do so. And for an institution, the Supreme Court, that has most often throughout its history been in the pocket of hierarchy and privilege and domination and those who would subordinate, you could imagine that they don't like this very much. And so one of the projects of this court, stretching back to the 19th century with a brief exception in the 20th, but occurring again after the 1970s, has been to limit the scope of the Reconstruction Amendments. And the substitution of an anti-subordination principle for an anti-classification principle is part and parcel of that attempt to limit the Reconstruction Amendments. To say, to borrow from Justice Roberts' language in the 2007 case, that the way to stop discriminating by race is to stop discriminating by race. To say that the recognition of race in furtherance of trying to create a baseline of equality, the recognition of race in order to unwind systems of subordination, is exactly the same under an anti-classification view as the use of race to discriminate people to subordinate them. It is quite literally the drill tweet as Supreme Court jurisprudence. The wise man bowed his head solemnly and spoke, "There's actually zero difference between good and bad things. You imbecile, you fucking moron." That is what the Supreme Court says with regards to race and the use of race to deal with subordination. That it's the same as doing it to discriminate. And so the upshot here is that the Voting Rights Act, for all intents and purposes, is a dead letter. It does not work to actually protect minority voting rights anymore. There are a couple of things it may still do when it comes to access, language rights, and whatnot. But in terms of its main effect, to ensure minority representation and protect minority voting rights, it is a dead letter. And we are returning to a point in the court's sort of antebellum conception of states' rights, of federalism. We're returning to a point where states have broad leeway to effectively disenfranchise large groups of people within them. And this is all based on an extraordinarily myopic view of racial discrimination, in which unless someone, again, is turning direct to camera and saying, "I'm racially discriminating," it doesn't really count. I know that we live in a time of backlash and retrenchment and reactionary energy. And I know that it seems hopeless. I know this. I am not naive. But when I think about this ruling and when I think about its progression, I think about the long movement of conservative energy it took to produce this success for their movement, right? To gut the Voting Rights Act. I also think that this opens up opportunities to maybe try to imagine a way the world could be better. A way to try to imagine a way that we can take the anti-subordination principles of the Reconstruction Amendments and make them real. I think in the face of MAGA movement, of the drive for restrictive citizenship, of the attempt to define the country as narrowly belonging to a small handful of people, I think in the face of that, maybe the only political project worth pursuing is one that will take the egalitarian promise of Reconstruction, that will take the anti-subordination principles of the Reconstruction Amendments, that will work seriously to try to make those real, to try to make a country of equal rights, of equal justice, of equal opportunity. And to try to do that in a way that helps us all recognize our inherent value as members of this society, as people whose actions matter, as people whose voices matter, as people who do not exist to be pushed around by those who just happen to have a little more money and a little more power than we do. And I do think that those of us who believe in the possibility of a better world also have to recognize that we may not actually see it. That one thing this tidal wave of reaction is telling us is that we're going to spend a long time fighting back and clawing back what we had, a long time trying to produce something not just better, but again, truly just, truly decent, and that this may, in the end, be the work for people after us, and that our job in this moment is to find a way to carry the baton of a more equal and more just and more fair country and move it forward as far as we can. In this, and I'm going way too long here, in this, I'm going to leave you with the example of the Americans who existed in the midst of the slave system, of the Americans who existed in the midst of Jim Crow, who had no choice but to do the work, who could not see that they might succeed, who did not expect necessarily to succeed, but who nonetheless did the work for the sake of those that might come after them. The Voting Rights Act might be dead, but the dream of an egalitarian, multiracial democracy is not dead. No one can kill that. The only people who can kill that are ourselves. We're the only ones who can put that dream to rest. So I think my final thought here is long live the Voting Rights Act. Really, long live the Voting Rights Act. Long live what was a representation of our desire to build a better country, and long live the aspiration to continue that fight to build that better country. See you next time.